Good morning, everyone, and welcome to the webinar on COVID within Workers' Comp. My name is Michelle, and I'll be your webinar moderator today. Today's webinar is sponsored by NatRed's Platinum partner, PACCAR, and the dealer network. Whether it's moving freight across the nation or going the last mile, their DAF trucks are always delivering. Today, you'll be hearing from Aidan Burton, Account Executive at AEI Insurance. With 3 years of experience in the New South Wales Workers Compensation Scheme, Aidan has spent the time both on the insurer side and now the broking side supporting his clients. Like always, we'd love to hear from you during today's presentation. If you have a question, please feel free to type in your questions in the Q&A section at the bottom of the screen. You may send in your questions at any time during the presentation. We'll be answering the questions at the end of the session. So welcome, Aidan. Over to you.
Thanks, Michelle. Hi, guys. So today we'll be going through workers' comp and the impacts of COVID on your premiums and how COVID positive claims and adverse reactions to the vaccine are claimable under the schemes in each legislation across Australia. I'll go through a brief overview of each state and whether a notification is required and what is compensable. And we'll start off with that. So on the screen, we have a state-by-state breakdown just showing each state and territory where a notification would be required for any COVID-related claim and if it is compensable for the claims. The only states that will not require notification would be Victoria, Northern Territory, and WA, with claims being compensable under the scheme in each state respectively. So legislation for each claim, we'll do a state-by-state breakdown, starting with the ACT. So for COVID positive claims, so a work cover certificate of capacity needs to be submitted, which will then be assessed by the insurer. If it fits the definition of a workplace injury, this would be assessed as any other claim would be, in which it would process as a claimable and a compensable injury. Moving on to Northern Territory, again, it would have to be reasonably reasonably confirmed that the workplace is the area where COVID was contracted. The claims process is the same, where they'd run through the same test to confirm if it is a workplace injury or if the worker is a worker. From there, it would be progressing as a normal claim. South Australia, the claim needs to be made within required timeframes. And again, there has to be a diagnosis of COVID-19 in which the exposure has to be contracted in the course of employment or that work was a significant factor. In relation to an adverse reaction to the vaccine, in the ACT, the claim needs to be lodged, in which it would again be assessed as any other claim to verify that it is a workers' compensation claim. In the Northern Territory, claims are considered on the individual merit. The policy to vaccinate the employee would be then reviewed to see if this was a risk that was increased by the employment. In South Australia, a worker can lodge their claim if they would like to, and the claim is assessed through the standard process. Again, this must show an injury that occurred and that work was the substantial contributing factor. In Queensland, a COVID-19 positive claim may be made and will be assessed under the similar lights of any other claim. WorkCover Queensland will not pay wages that are lost for quarantine time unless there has been a COVID-19 diagnosis, exposure is confirmed to be connected with the workplace, and that there has been an accepted COVID-19 claim. The acceptance of the claim in Queensland would be based on whether the claim had been made within the required timeframes, that the worker was in fact a worker, and that the injury is a confirmed diagnosis of COVID-19. In New South Wales, when deciding to accept a statutory claim for COVID, it's the same principles that are as above. The injury needs to be a diagnosis of COVID-19. The worker must be deemed a worker, and it must have been contracted in the course of work. However, New South Wales is one of 2 states that currently has a retail industry presumption that the worker contracted COVID-19 in the workplace, in which there still needs to be a causal connection that the workplace was where COVID was contracted. In Victoria, COVID can be considered compensable as this is a disease. Again, the injury must be a confirmed diagnosis of COVID-19 and the exposure must have been in the course of work. With Queensland, an adverse reaction can be claimed through workers' comp. However, the employment needs to be deemed a significant contributing factor. This can be seen the same in New South Wales and Victoria. For Tasmania, COVID-19 claims are compensable. Again, a diagnosis of COVID-19 must be seen alongside employment being the substantial contributing factor and where the employee has contracted COVID. In WA, again, COVID is compensable. However, it must be deemed that the worker has contracted COVID through employment. An adverse reaction is that a claim can be lodged in TAS and it will go through the same claims process and screening to ensure that this is a claim as any other claim would be. For WA, it is the same where the claim will be assessed as a normal claim and it will go through the same screening process. On adverse reactions to the vaccine, the federal government has set up a scheme in which people who have suffered an adverse reaction to the vaccine are capable to claim. This covers any persons who has had a reaction from February 2021. This is separate to the workers' comp schemes and runs under a different legislation. And I'd advise that you speak to your employees and those who have had any adverse reactions, review this scheme. In relation to impacts on premium, New South Wales has noted and iCare have noted that COVID-19 related claims will not be impacting premium. Victoria, we are still waiting on further information to come out from WorkSafe Victoria, which we are anticipating to hear more come the June 30 renewals. Queensland have not made any statements, and so we are running under the assumption that COVID-19 related claims will be running as normal claims and will be premium impacting. With South Australia, there has been no clear advice provided by Return to Work South Australia, in which, again, we would run under the assumption that these claims will be premium impacting. For the underwritten states, being WA, Tasmania, ACT, and Northern Territory, underwritten, you'd need to confirm this directly with your insurer, as these are non-regulated states, and each insurer would have a different view. At this point, we'll open up the floor to any questions. So if you have any, please put them in the questions box.
Thank you, Aidan. So our first question is, does having a COVID-safe plan in place affect how my premium is assessed? If not, surely there should be some discount for a good plan?
Yep, so it's a fantastic question. So from the research done, no, this will not have any impact on your premiums. It'd be the same as any safety measure. A lot of insurers don't see this as we should be rewarding you for your safety. It should just be a standard business practice.
Okay, I have another one here. Can I claim for business interruption when I can't meet my contract requirements because a number of staff are isolating or have COVID?
Yep, again, another fantastic question. I'll actually be passing over to one of my teammates, Steve. So Stephen McCool.
Good morning, everyone. Look, at the moment, these sort of claims are running through the federal court, the High Court of Appeals. So it depends on the policy wording you've got on your business interruption policy. And the only advice we can give you at the moment is lodge the claim as you would normally with the underwriter to assess it against the policy wording, terms and conditions. There was a full sitting of the federal court bench on 21st of February, which indicated that the insurers were not liable to indemnify clients on their claims under the business interruption policy, as the clauses weren't triggered in the policy wordings. What's happened subsequently, as of last month, as of 21st of March, is there's been 3 special leave applications made to appeal the full court decision. So that at the moment, as most of you will be aware, whenever the lawyers become involved, it drags out. So at this stage, the Insurance Council of Australia has basically indicated that there's somewhere in the vicinity of 3 months for these special leave applications to be heard. And if the High Court decides that it will actually review these applications, it could be 12 months in total before we have any definitive legal precedent set or direction. So the short answer is no. The business interruption policies in the interim on the whole do not cover COVID claims. However, I would recommend strongly that you do lodge a claim as normal, speak to your broker, look at your policy wordings in the interim if you're up for renewal, making sure that there are no specific clauses to exclude coverage directly, as this will depend on the underwriter interpretation and review of the policy wording once you lodge a claim. At this stage, until we hear anything further from the federal or high court, there's no legal requirement for the insurers to honour a claim for COVID under your business interruption policy. I hope that makes sense. But it is a bit of a case-by-case basis, depending on your underwriter, the policy wording, and what you're covered for specifically, and what exclusions you may have listed on your policy documents.
Thanks very much. We have another question. How do we know if the worker got COVID at work?
Yep, so that's a fantastic question. So it would be based on further diagnosis. If there's other instances where the workplace has seen positive cases, then that would be one linking factor to say that the worker has contracted it at work. However, being that we're looking at a transport industry, it could be that any site that they've visited that has had a positive COVID case could be deemed a substantial contributing factor, in which would be linked to their workplace.
Thank you. I have another one. Will insurers have access to contact tracing from state health departments to determine source of contagion, or will it be taken at face value from workers' hearsay?
Look, that's a hard one. From my understanding with previous clients, particularly last year or two, the contact tracing information has not been accessible to insurers. It's governed under different legislation to workers' compensation, and as such, insurers don't have access to that. It is predominantly taken at face value, but to Aidan's point earlier, if your work site has had previous instances of COVID infections, if the employee is travelling to multiple different sites with a history of COVID infections, it's going to be very hard pressed under the workers' comp legislation, where an injury could be a contributing or substantial contributing factor. The claims would be assessed on that basis under the workers' compensation legislation. What I would suggest to everyone, if possible, as part of your risk management processes, that you undertake a phone call, an email, a survey of your client sites that your employees are travelling to, and request clarity on any recent infections on a regular basis to update your own registers. So should a claim be lodged and you have no instances of COVID in your work site, then you can trace back to other sites that the employee has visited, and whether they've had a historical infection there may be where the source is coming from. It's very much a fluid situation in regards to apportioning risk or liability, and then, you know, is there an argument around subsequent recovery against that employer that your employee has travelled to? So it opens up a whole different sort of legal aspect on the claim if lodged, and whether the evidence is there to substantiate work being the actual factor. So there could be a family history of infections that you're aware of, and that might be a separate question to the GP or doctor if a claim is lodged around clinical notes for the worker as well. especially if you've got no recorded instances on site.
Right, thank you. I have another one here, but employees do not declare where they have attended in their personal time. That's just to follow on from the previous question.
In terms of them attending in their personal time, can I clarify the actual question?
Yeah, so but employees do not declare where they have attended in their personal time. So I suppose that if this is from Scott Brown, he must mean, so you know, if they don't say where they've been personally,
yeah,
how would you know?
Oh, sorry, got you. Okay, sorry, thank you. I was a bit confused there. Look, there's nothing we can do around what they do in their personal time. You're relying on the worker being honest and upfront. If there's questions or concerns around the claim, then every state allows for clinical notes to be changed from the GP. That may shed light on any information as to how it's work related. But as I'm sure most employers would have discovered, that often what they do in their personal time becomes a work issue and subsequently intertwined with a workers' compensation claim. All we can do is ask, as part of the lodgement process, are there any other mitigating circumstances, obtain statutory declarations in some instances from the worker via the insurer as part of the liability process, and if warranted, factual investigations in some instances as well. Particularly if the worker is more seriously impacted by such things as long COVID versus the short 7 to 12 day type cold symptoms. Again, and this is something that I think by all means feel free to give us a call separately if that situation does arise moving forward, because part of our process is to question liability where it's warranted and ascertain compensability in line with the legislation, separate to personal mitigating factors being involved as well.
Right, thank you. Well, we have no more questions. So thank you, Aidan, and thank you everyone for attending today's webinar. If you have any other questions, please send an email to info@natroad.com.au and we'll pass it on to the team to have it answered. Today's webinar will also be uploaded to the website, so please share it with your colleagues. Have a great day and thanks very much.
Thank you.
Thank you.
Bye. Bye-bye.